Mesdames et messieurs dans la salle, mesdames et messieurs qui nous écoutez en ligne, bonsoir. Les gens dans la salle, merci de vous être déplacés malgré la température et les problèmes de transport en commun. Bien que la grève de transport soit terminée, c'est quand même toujours compliqué. Je me présente pour ceux et celles en ligne qui ne me connaissaient pas. Mon nom est Nicolas Vermel, je suis directeur du Centre de recherche en droit public et il me fait plaisir de vous accueillir à cette deuxième soirée de la justice pour le cycle 2025-2026, un cycle qui porte sur la thématique Justice pour tous, Justice for All. And I'll switch to English since our lecturer will be presenting in English. So tonight we have the pleasure of welcoming Gérard Kennedy. Gérard will be presenting a talk which is titled Fighting the Backlog, How Ontario's Courts Are Using Summary Processes to Address Civil Justice Delays. And among other things, will address how it is helping non-represented litigants. Gérard has a very long CV, and so since I'm sure you'd rather hear him speak than hear me say how wonderful he is, even though I can confirm that he is, both personally and professionally, I'll simply mention that he's currently a professor at the University of Alberta Law School, where he's been since 2023. Before that, he was at the University of Manitoba's Faculty of Law for a number of years. He also worked in private practice at Osler in Toronto before being a professor. He's authored and co-authored a litany of journal articles as well as books. In fact, I currently, and I'm not supposed to show you this, but I currently have a pre-issued version of his latest book, Civil Litigation, the second edition, which should come out in the next couple of weeks. I've accepted to read this to give a blurb on what I think about it. And I will tell you right now, it will be a very positive review, as it is a fascinating read. And so on that note, Gérard, thank you so much for accepting our invitation. And I cede the floor to you, sir.
Well, thank you very much for that very kind introduction and a very kind invitation to be with you here today. As discussed, I am going to be presenting on recent reforms to Ontario civil procedure, which are no longer that recent because they're 15 years old, and yet they're already being reformed again. And I'm going to look at a bit of an experiment that Ontario has had, specifically in the area of summary judgment, and how it has been used as an effort to achieve and address a general backlog in the courts with the goal of facilitating access to justice. I will be doing this largely. I will be introducing the general law of summary judgment because I know it doesn't really exist, not in any analogous form in Quebec. Why the law in this area was changed in 2010, how the courts have actually received this change in the law. I'll then introduce the project that I've been working on with Suzanne Kyoto at Osgoode Hall Law School and Alyssa King at the Faculty of Law at Queen's University. And specifically, I want to introduce to you what we have learned about how the courts have received this interesting tool. Why some trends that we expected to find might not actually have been realized, where we're going to go next in our research, particularly with the view to the experience of self-represented litigants, and finally, why is Ontario changing course so quickly? So, what summary judgment is? Summary judgment is a shortcut to judgment that deals with the facts of a claim. A summary judgment motion allows a court to give an adjudication on the merits that resolves a claim on its factual issues. This is to be contrasted with other what you would call procedural determinations of a claim, such as default proceedings or dismissal for delay or dismissal for failure to comply with the rules, all of which do resolve a pleading, but aren't considered to develop the law in any substantive way. And if a litigant later tries to say this has already been litigated, it hasn't been resolved on the merits. You can also, though, have shortcuts to judgments that are considered meritorious. Historically, in the common law, this could always be done with respect to the law, in the sense that if someone brings a pleading, but even if everything they say in their pleading is proven to be true, they won't win as a matter of law, that pleading can be struck on a motion to strike or a motion to determine a legal question. So if someone sues someone for a broken heart, to use a silly example, the court's going to say, the law doesn't recognize this, your claim is over. Usually things are not that extreme, but you could have an instance where someone brings a claim for nuisance, but their facts allege or are lacking what is an essential element of the tort of nuisance. The court will just say, no point in having a full trial on this. You lose as a matter of law, even if everything you say is factually true. Why would we go through that whole factual fact-finding process of the trial to resolve the action? Might there ever be instances, however, where the facts can be resolved without a traditional trial? Historically, the common law was very reluctant to do this, largely because it viewed the trial as the paradigmatic way to resolve an action on its merits, and dispensing with that would be a quintessential procedural injustice. But beginning, I don't know, about 160 years or so ago in England, it was recognized sometimes there are cases where the facts are really simple. Not so simple that you can dispense with them on a pleadings motion, but historically this emerged in a debt collection case. Let's just say that Nicolas and he had lent me some money because he's very foolish in that way. I had refused to pay him back. He sues me. I put forward a specious defense that he never lent me the money or that there were terms that obviously didn't exist. All that is doing is delaying his ability to collect on a debt that he's obviously entitled to. So courts in debt collection cases used to begin to allow summary judgment on the basis of affidavit evidence. But historically, the facts had to be virtually incontestable. Someone says, I wrote the check on X date, I've never been paid back. Defendant gets a chance to say, well, actually, I did pay him back or not. But if defendant can't say that, well, then you could give summary judgment to the plaintiff. But again, very high bar. That has slowly but surely been liberalized over about 100+ years, where if the facts were pretty clear, you could grant summary judgment. If there was no genuine issue for trial, where this is often done relatively uncontroversially is in wrongful dismissal cases where just cause isn't alleged. I know the law isn't precisely the same here in Quebec, but in the common law provinces, you can dismiss someone without cause in a non-unionized atmosphere, so long as you give them notice or pay in lieu thereof. And to determine what that notice is, you need to determine, well, how old is the person? How available is alternative employment? How long did they work? What's the nature of the employment? You need facts. You can't assess that just on the basis of the pleadings, but they're relatively incontestable. Let's get this done by way of affidavit rather than having an expensive trial. Now, to be sure, on a summary judgment motion, parties are entitled to cross-examine on affidavits, but it's supposed to be relatively discreet. The whole point of these summary judgment motions is to ensure that there is greater access to justice. That for a case that doesn't require a traditional trial, sometimes even doesn't require a traditional discovery process, that there can be a shortcut to get a judgment. That's the rationale. How far can we take that rationale? Well, in 2005, the Ontario government retained Coulter Osborne, a retired judge of the Court of Appeal, to prepare a report that recommended a bunch of changes to Ontario's rules of civil procedure. He made many recommendations, two macro level ones that I think are worth unpacking in greater detail. One was that the principle of proportionality should be enshrined throughout Ontario procedural law as an overarching principle. that all steps in civil litigation need to be proportionate to what is at stake. This is subtly different than efficiency. It recognizes that there are times where extensive process is proportionate given the gravity of the issues at stake and how much a particular step will further it to it. But we also need to ask whether having, let's just say, an interlocutory motion over document 42 is actually a good use of anyone's resources. So he says, always consider proportionality. He also recommends that the availability to grant summary judgment be liberalized. Specifically, by changing the historic standard of granting summary judgment if there's no genuine issue for trial, to if there's no genuine issue requiring a trial. In other words, only if a trial is necessary should summary judgment be refused. Justice Osborne's rationale is that we want to get more civil actions resolved on their merits. This will help develop the common law. It will also ensure that parties are able to get their cases resolved in a public system with basic procedural fairness, because as advantageous as certain doctrines like or procedures like arbitration and mediation are, they do occur in private. They don't develop the common law. They can descend into the sport of kings. We might not necessarily want that. The Supreme Court of Canada ends up interpreting these amendments in a case called Reiniak and Malden. First and foremost, I want to plant a flag in here. It's a bit unusual that the Supreme Court would grant leave to appeal in a case that deals with a particular province's procedural law. You would not think this is an issue that is of national importance almost by definition. Clearly, the Supreme Court thought that it needed to make some statements, specifically about a need for a culture shift in how litigation is conducted, all with the view of access to justice. I'm going to talk about what Justice Karaksanis said about the law in Reiniak momentarily, but I want to take a bit of a discussion about the facts, because it does illustrate how we thought summary judgment was going to get liberalized, become available more frequently. This is a fraud case. Mr. Reiniak was a financial planner wizard of some sort who was approached by a group, or he approached a group of investors called the Malden Group, and basically persuaded them to invest money with him. They invested over $1 million. A few months later, the returns are very good. They invest more than $10 million with him, and then the money disappears. So they sue him for fraud. They also sue Cassels Brock, the law firm, for their role in this whole saga. Mr. Reiniak asserts the money was stolen by a rogue. I don't know who, but it was. Somewhere in the Caribbean, a rogue stole the money. Not surprisingly, not a lot of people believed him. And so the Malden Group brings a summary judgment motion seeking to have a fraud judgment against Mr. Reiniak purely on the basis of affidavit evidence. He says, this is not appropriate. The plaintiffs have brought five bankers' boxes worth of materials saying everything that went on. This is the kind of information that needs to come through a trial. Moreover, this fundamentally is about whether or not the trier of fact believes me. That has got to be adjudged in court at trial, not on the basis of affidavit evidence. The Superior Court judge, Justice Grace, says no. Yes, the bankers' boxes are voluminous, but they're fundamentally documents that can be explained to me. No one's really doubting what they mean. Moreover, this case, again, fundamentally comes down to whether or not I believe Mr. Reiniak, and I simply don't. And I don't see what having a full trial is going to add in this regard. The Ontario Court of Appeal upholds that, but they do so reluctantly. They say, this is not the kind of case that should get summary judgment. The documentary evidence is way too long. We should have a trial to explain it all. Moreover, we should be very reluctant to determine credibility on a summary judgment motion. They do uphold the judgment, but largely on the basis that Mr. Reiniak's defense is really weak, and sending this whole case back to start would be unfortunate. So they uphold the granting of summary judgment, but they do so reluctantly. And the Supreme Court, somewhat surprisingly, agrees to hear the case. Not only do they uphold the granting of summary judgment, their rationale is much more similar to the trial judges. Justice Karakatsanis says, we need to move away from viewing a traditional trial as the only way to have fair process. A summary judgment motion on the basis of affidavit evidence is an entirely legitimate way to resolve an action with basic procedural fairness, developing the common law to ensure that we have access to justice in our society. We should only refuse summary judgment if a trial judge feels unable to grant it, considering these three criteria. A trial judge needs to be sufficiently certain that she can make necessary findings of fact, apply the law to the facts, and be satisfied that the summary judgment motion is a proportionate, more expeditious, and less expensive means to adjudicate. She says the trial judge needs to have sufficient confidence in this regard, but her decision should be given significant deference by the appellate courts. And the standard of review on questions of fact and mixed fact and law should be palpable and overriding error. She notes that the 2010 amendments in Ontario, which were the consequences of Justice Osborne's 2007 report, give judges new powers to hear limited viva voce evidence that's live in person on a summary judgment motion, as well as to weigh evidence and make determinations of credibility. She says, we often won't even need to resort to those powers. Often credibility at trial, not much is added. I mean, actually, modern psychology is pretty good at showing our ability to tell whether someone is lying by seeing them in person is limited, to put it mildly. And you know who's really good at convincing you they're not lying when they are? Con artists. She didn't say that, but psychological literature says that. So she doesn't see any reason why summary judgment isn't appropriate if there's credibility at stake. She does agree, this is one of the problems with summary judgment. If summary judgment is sought inappropriately, the summary judgment motion can itself be the source of enormous delay and expense, because you have this significant interlocutory step, lots of time and money spent on it, and then you don't resolve it. That is a problem. But she says there are ways to mitigate the problem. One, by seeking directions in advance about whether summary judgment's appropriate. That mitigates the likelihood the summary judgment motion will be denied. Moreover, a judge who refuses summary judgment because she believes there's a genuine issue for trial can, one, remain seized of the matter, so they don't have to get completely up to scratch at trial, and make directions to make sure the trial proceeds efficiently and fairly. So she says, all of these reasons, we should use summary judgment as a valuable tool, not a panacea, but a valuable tool to resolve civil actions on their merits more quickly, with less expense, achieving access to justice. And she says, notwithstanding some credibility issues in this case, she has no hesitation in upholding Justice Grace's opinion. So what happened? Well, the early years after Reinyak did show some uptick, significant uptick, in the seeking and granting of summary judgment in Ontario. There was very good work done by Brooke McKenzie. She's a lawyer in Toronto, but she did graduate work before committing to a career in practice that comprehensively analyzed the practice in Ontario before the 2010 amendments and after. And she noted there's a significant increase, about doubling, the rate of people seeking summary judgment. There was a dip after the Ontario Court of Appeals decision that then picked up again with an increase after the Supreme Court of Canada's decision. And there was also an increase in the rate it was granted. Interestingly, she noticed that the increase in the rate it was granted was not as much as the increase in people seeking it. So if the rate of seeking it went up by about twofold, the rate at which it was granted went up maybe by a bit 1.5. But still, the number of cases being resolved summarily significantly increases because of a larger denominator. And again, still an increased rate in people seeking it. Notwithstanding that, when I did some research, qualitative research on access to justice needs in Ontario in 2019, I heard lots of anecdotes that there was tapering enthusiasm for this. Some of the reasons included the Ontario Court of Appeal continuing to be skeptical of summary judgment. Some of it was that it was really confined to very strong and very weak cases, which I'll add is not nothing if you can resolve very strong and very weak cases more quickly, but that's still good. But that perhaps what people thought was going to stick as a new practice maybe wasn't. But again, this was merely anecdotal evidence I was picking up through conducting surveys. I also have noted, and as has my colleague Barb Billingsley, that there was minimal uptick of the general call that Justice Keir Katsanis noted in Raniwak for a culture shift outside the narrow area of summary judgment. So you might think that motions to strike or determine a legal question would also see an uptake in, given the spirit of Raniwak and resolving cases on their merits would appear to apply to them. We didn't really see that. And similarly, when we looked in other provinces, I did some work in Manitoba, some work in the federal courts, Raniwak per se, pretty minimal uptick. Professor Billingsley and her work in Alberta shows, maybe a bit more there, but still, provinces tend to march to the beat of their own drum, and broad pronouncements of the Supreme Court about how they should interpret their procedural law, unless they're very particularly told, may not have had that much of an impact. So, what am I doing now? Well, with my colleagues, Alyssa King at Queen's and Suzanne Kyoto at Osgood, I am currently analyzing the extent to which these tools, like summary judgment, are being used now. Our particular motivation was whether there'd be even more motivation to use such tools in the aftermath of the pandemic, because we thought there's going to be a huge backlog of the courts. Courts will use summary processes to get matters through the courts more quickly. That was our initial hypothesis. And then we further heard, Ontario's going to amend its rules again. Let's see how the current rules are actually working in practice. And so you get the first presentation tonight about what we found from an empirical perspective. And we are continuing to work on qualitative interviews and courtroom observations in this regard. In doing so, we're also hoping to replicate and follow up some work that I and others did back in earlier in the past decade. Before I show you what I found, however, I want to give you a little bit of a methodological rant. We primarily encompassed our data, very much in the vein, by the way, of what Mackenzie did in her article, using Westlaw, which has a bunch of helpful searching tools based on everything that you find on Canley, plus then some. We acknowledge Westlaw does not capture every decision. If something isn't reported, if it isn't given a neutral citation by the Ontario Superior Court, it's not going to show up in Westlaw. And we know there are such cases out there because some judges, for various reasons, don't report their decisions. Insofar as this is a limit, we have no reason to think it's not a random limit. So the general trends we're observing will hopefully remain the same. We were really hoping to spot check our work through the Ministry of the Attorney General figures in Ontario. The Ministry of the Attorney General of Ontario has a database called Frank that gives aggregate numbers of cases commenced and disposed of through various procedural mechanisms. It didn't take us very long to figure out these statistics are clearly wrong. And we were not the first people to observe this, but we noticed this for several reasons. There were some years where they were reporting a plausibly higher number of cases and judgments, and yet others where they were reporting fewer cases and judgments than Westlaw was. And there was no way that could make any sense. We also noted that it was systemically biased to overrepresenting cases in Toronto in a way that did not pass the smell test, and minimal complementing of reported decisions could illustrate was wrong. I think it would be great if we had comprehensive government database that was accurate, that showed us these figures even in the aggregate, because as we're going to come to when we see what Ontario is doing now, there are very strong opinions on how we should fix the civil justice system, and the extent to which they're backed up by reliable data is something that people debate, and not having a reliable government database is a limitation, to put it mildly. Nonetheless, we got to do what we got to do. So what did we discover from Westlaw? This chart illustrates summary judgment motions decided over the past decade by year and their success rates. All right, I'm going to show what each line is. That top line, that's black. It illustrates the number of summary judgment motions brought. We notice from 2015 through 2019, pretty consistent numbers, between 350 and 390 cases a year. That's a variation of less than 5% from the mean. Nothing unsurprising there. Pretty consistent. And if you compare it to the numbers before the 2010 amendments, much higher. Then it drops off like a cliff in 2020. Now, that's not terribly surprising because 2020 is the pandemic year. Obviously, there were going to be delays and courts were not going to prioritize hearing or deciding summary judgment motions when the courts have very limited operations. We need to prioritize the criminal cases and the family cases where there is acute urgency. So the fact that we would see a drop off in 2020 wasn't surprising. Here it was surprising. We didn't see the numbers increase thereafter. On the contrary, and sorry, this is, let me move this for people in the room. On the contrary, we see the numbers remain pretty similar. It goes up a little bit in 2021, which is probably clearing the backlog from the year before, and then it remains low. Why the drop off? I'll tell you why at the end, why we think there might be drop. It's probably not a monocausal thing, but this certainly does not appear to be within the spirit of Rhiniak or the 2010 amendments. So what happened? Well, before I get into that, I want to show what the other lines show. The teal line, or maybe light blue, Professor Kyoto's already made these, so thank you, Alyssa. The teal line shows the number of motions that were at least partially successful. The dotted line shows the results at the trial court. The solid line shows the results after the appeal process is over. We see in the early years, the rate of success, or at least partial success, is in about the 65 to 70% range. As we go on, we see that the gap between partially successful motions and total motions is narrowing. We're now more in the 75 to 85% success range. So people are bringing motions that are likelier to succeed, which is a good thing. We have fewer unsuccessful motions, but the total successful motions in absolute numbers is still below what they were. So we have competing goods in this regard. We have fewer unsuccessful motions that delay the matter and don't resolve the case, but fewer actually successful motions that summarily resolve the matter. What's going on here? We also note that the rate is significantly lower, well, significantly is a stretch, consistently lower of success after the appellate process and before the appellate process. Trial courts are consistently more likely to grant summary judgment than appellate courts are. There are individual cases where that's not true, but in the main, trial courts or appellate courts are much, aka the Ontario Court of Appeal, is much more likely to overturn the granting of summary judgment than the declining to grant summary judgment. Just so you know the difference between the orange and the yellow lines are, these add up to the teal line. These illustrate the number of motions that are completely successful in disposing of the action compared to those only partly successful in disposing of the action. Partial summary judgment is relatively rare, as you can see. And we're going to come back to that in a bit. Okay, let's build on that. Let's look at how often summary judgment decisions are appealed and how often they're overturned. This chart illustrates the number of summary judgment motions that are appealed per year. We see fewer cases getting appealed as the years go on. This basically, though, matches that there are fewer motions as the years go on in the subsequent 5 years. What is clear, however, is the extent to which appeals are being allowed is going down. The blue figure you see at the top of the bar is the where appeals are allowed, at least in part. And they, as a percentage of appeals being successful, is going down. So therefore, not only is the rate of success going up as the years go on, even though the total numbers are going down, the likelihood that the Court of Appeal will interfere is also going down. I would suggest that might indicate the law is stabilizing, which, is probably, other things being equal, a good thing. What does the Court of Appeal do, however? Well, I have 6 things the Court of Appeal could do. A summary judgment motion could have been dismissed at first instance and granted on appeal, dismissed and partially granted on appeal, partially granted at first instance and dismissed on appeal, partially granted at first instance and allowed on appeal, granted at first instance and dismissed on appeal, or granted at first instance and only partially granted on appeal. By far the likeliest thing the Court of Appeal is to do is to take a motion that was granted at first instance and dismiss it, basically holding summary judgment was inappropriate. That's the blue line. It dwarfs the others. The second one I'll add is the green line, where something that is dismissed at first instance is granted, but it's still significantly below. The red line, which you also see quite a bit, is where something was partially granted at first instance and then dismissed. In all cases, we see the Court of Appeal in the main more likely to overturn the granting of summary judgment than the not granting of summary judgment. The one exception is the 2024 year, but I take that as a massive grain of salt because the appeal process is not done. The N is only 16. So far, the only allowed appeal from a 2024 decision is actually granting something that was denied at first instance. But when the N is 1 from a total of 16, I think we need to take that with a significant grain of salt. In the main, the Court of Appeal is more likely to overturn than the granting than the overturning of the not granting. This is also very interesting. And now I'm going to start to say why the numbers have been moving in the way they are. These are the trends in Toronto. So I earlier showed you what the court was doing across the province. Within Toronto, we see the numbers of summary judgment motions being brought from in 2015 at 200 a year and then floating in around the 170 to dropping to well under 100 in recent years. So across the province as a whole, the rate has dropped by not quite half. In Toronto, it's dropped by more than half. So there are fewer motions being brought in Toronto. But the extent to which they're being successful is now 80 to 90%. Motions that are brought in Toronto are successful, despite exceptions, but in the main. This, I think, is because in 2016, the Ontario Superior Court in Toronto said that anyone who brings along the motion needs to go to scheduling court first. And they basically were not letting one schedule a summary judgment motion if they didn't think it was appropriate, which I think disincentivized certain motions, and to the extent they were allowed or were likely to be successful. And in 2022, that was made for all summary judgment motions, whether a long motion or not. So that probably explains what's going on in Toronto, which, given that it's such a large part of Ontario, is going to affect the numbers. Because then when we look at the trends outside of Toronto, the numbers, the trends still go in the same direction as the province as a whole, but they're flatter. There's not that 2016 drop off. There's the 2020 drop off, And the numbers post 2020 never quite get to where they were between 2015 and 2019. But the numbers of motions brought are not going down to the same extent. And while the rate of success, in other words, the gap between the top line and the lower lines, while it's decreasing, it's not decreasing to anywhere near the same extent. There's still much greater likelihood of an unsuccessful summary judgment motion being brought outside of Toronto, and that would appear to be because of the Toronto practice. This is not the only reason I think the trends have been going, but I think I have to flag that here just to put these charts in context. One of the reasons people lament summary judgment motions and think they're not necessarily a bad thing is that they can delay things. Now, ideally, we would have been able to see what the gap was between a notice of motion being served and the resolution of a motion. The problem is we don't have access to that data, and no database will give you access to that data. The only way to figure that out would be to look at each court file individually to figure out when the notice of motion was served, which would have been prohibitively time consuming. What we did, however, look at, because I think this is not as valuable, but still interesting, is how long it took a judge to decide a motion from the time the motion was heard until they resolved it, until they gave their reasons. And we noted that the average days obviously vary if there's an appeal or and they vary by year, but they range between about a month and a half to 6 months, which is not great. We don't want things delayed that long, but in the grand scheme of civil litigation delay, that's not enormous. And when we exclude some extreme outliers and we instead concentrate on the medians, we see those numbers go down even further. Indeed, the median day for a judge to resolve this in some years, if there's no appeal, is less than a month. So judges are pretty good at resolving these things. Does this mean there isn't significant delay in getting the motion date? It does not. We have significant anecdotal evidence that that's the case, and I see no reason to doubt that. But judges are pretty good at resolving the cases once they come forward. One thing we did want to note, however, and this is a collateral point in our analysis as a whole, but I do think it's interesting. We looked at the 5 judges who deal with summary judgment motions most frequently. I have them up there: Paul Perel, Ed Morgan, Mario Feta, Fred Myers, and Sean Dunphy. Did they decide these cases differently? Because there's a hypothesis in lots of access justice literature that if we have more specialized judges, things will be done more quickly and better, and that will be all to the boon. It's sometimes criticized, and Peter McCallison recently noted this in an article. There's not a lot of data supporting this. There's a lot of people's strong suspicions. So we looked, are judges who deal with these motions most frequently going to decide them differently? And we noted that in terms of how likely they are to grant the motions, some judges, Justice Perel, Morgan, and Myers, were more likely to grant the motions than the average.
Oh, he's such a fucker.
Others, someone might want to mute themselves. Others, Justices Fietta and Dunphy, however, were less likely to grant the motion than others. What we did note, and was undeniable, these judges were way faster than the average. All 5 of them, Justice Fietta less so, but certainly the other 4, were way quicker at resolving these motions than an average judge would be. In Justice Morgan, it's actually quite extraordinary. The median time he took to issue a summary judgment motion, the reasons, was a day. He probably has certain boilerplate and template going, and we can debate whether that's good or bad. But in terms of at least speed, which other things being equal is a good thing, this is maybe some small data point that judicial specialization has advantages. Okay, last piece of data I want to flag. Oops, that's not right. Before I start explaining why the trends have been as they were the extent to which parties were represented. Julie McFarlane, who's a professor at Windsor and has significant expertise in the experience of self-represented litigants, has queried whether summary processes particularly disadvantage self-represented litigants who particularly benefit from in-court time to explain their case to a judge. And I suspect there's probably something to that. She also notes that depending on the area of law, up to half of civil litigants in Ontario are self-represented. And yet we see nowhere near that level of self-representation in summary judgment motions. The red on these charts are the percentage of motions where at least one side is lacking a lawyer. It's consistently a pretty small minority, between 10 and up in recent years to 25%. Now, that's not nothing, and it is increasing in recent years, but I wonder if some parties recognize that a self-represented party isn't going to know how to properly respond to a summary judgment motion, which in turn will lead a judge to be less likely to grant the motion. And so it's not as large an issue as it is in other areas. Okay, so I think the overarching trend we see, broad encouragement of summary judgment, initial significant pickup, and then it goes down, although the rate of success goes up. Why is this? Well, one of them I've already told you because I couldn't explain the Toronto charge without doing it. There's a lot more triaging of the motions in Toronto in particular. If the judge at the scheduling court thinks that a case is not amenable to summary judgment, they simply won't let the summary judgment motion be scheduled, which is obviously going to decrease the number of motions brought and is probably going to increase the success rate. So I suspect that is a reason for this trend. But it isn't confined just to Toronto, like maybe the culture in Toronto expands elsewhere. The Ontario Court of Appeal in a 2017 decision called Butera significantly curtailed the ability to bring partial summary judgment motions, held that partial summary judgment motions should be truly exceptional for two reasons. One, a partial summary judgment motion by definition does not entirely resolve a case. So you have to have this side discussion, a procedure in the middle of the trial, which may not even involve all the parties who are just sitting there twiddling their thumbs, and you're going to have a trial anyways. If our goal is to achieve access to justice, the court is skeptical that that is the case. Moreover, if there has to be a trial on other issues anyways, then there's a risk of inconsistent results between the summary judgment motion and the ultimate trial. So the Court of Appeal says for these two reasons, we should be very wary of partial summary judgment motions. Oh, look, those reasons, there's clearly something to them. I also think if you read Roniak and its call for culture shift in litigation and recognizing the importance of developing the common law, there are arguments on the other side, especially as in some cases, a party will be extricated from the litigation of the partial summary judgment motion, or you just know the whole thing will settle. So there's something to that, but that's where the Ontario Court of Appeal laid down. And then I think there's the pandemic. Clearly, the pandemic was the catalyzing event, not the only one, that showed a drastic drop that we thought might in turn lead to greater use of summary judgment, but it's actually had the opposite effect. Maybe that's because it causes people to figure out what they really think is important to litigation, or it might bring them back to old habits of litigating that they had before what might have been the actual experimenting decade, which was the 2010s. Because I would suggest that culture shift, which Justice Karakatsanis called for in Roniak, is actually quite hard, and having an enduring culture shift can be quite challenging. And as I've also suggested in the past, that if you really want parties to behave differently in procedural law, you might just have to change the rules rather than telling them, well, you should consider A, B, and C and behave more differently. That has its disadvantages too. But all of these might point to something as a whole. Maybe summary judgment isn't that great as a solution to access to justice. Maybe there are some cases, very strong or very weak, where you can, through discrete evidence, show why it should be resolved quickly. but maybe in the whole there are disadvantages. Maybe having all of this time outside of court preparing affidavits and cross-examining on them isn't going to make things cheaper. It might make it quicker, but it might not make it cheaper. And maybe judges don't want to read all this information in a box. Maybe we are a little too reluctant to dispense with the trial. And I think we certainly see that in other provinces, including my one of Alberta, where summary judgment has been viewed, I think, with more skepticism. So what are we going to do next? Well, Professors King, Kyoto, and I plan on complementing our quantitative research with some qualitative interviews and surveys, as well as just going to motions court, seeing how it goes down. The three of us and group of RAs plan on observing, because by all means, read the case, I'll look at the numbers. It only tells you so much. And we particularly want to analyze this through the lens of self-represented litigants, who on the one hand particularly need access to justice and might need a summary process, but at the same time would seem to particularly benefit from in-court time. So these principles point in different directions. Interestingly, the Supreme Court has granted to leave to appeal another summary judgment case from Ontario. This summer, it granted leave to appeal the Arkham Electoral Services Limited case. This is a corporate commercial dispute. Justice Galeese for the Court of Appeal overturned the granting of summary judgment by the trial court for two reasons. One, while she accepted there was no genuine issue for trial regarding the plaintiff's claim, she nonetheless held that the defendant had a prospective defense that warranted a more fulsome hearing. And secondly, she said, there's a related action that's going on, and I'm worried that there will be inconsistent results if we have a summary judgment motion in the initial action. So let's consolidate them together. I have no dog in the hunt about that particular case. What I do think is interesting is the Supreme Court agreed to hear it, which again, for a provincial procedural rule seems a bit odd. Is the Supreme Court wanting to say more about Rhiniac? Is the Supreme Court wanting to say more about prospective new amendments to Ontario's rules? Because after these 15 years of the 2010 amendments, the Ontario rules of civil procedure seem posed for yet new significant amendments. And I will mostly talk about how they intersect with everything I've talked about summary judgment, and then I'll briefly foreshadow the two most controversial ones, because that is where it would be, I'd be avoiding the elephant in the room not to at least mention it. And full disclosure, I served on a subcommittee concerning recommended amendments to the appeals rules. No one seems too fussed about those. So either we weren't bold enough or we did a great job. I leave it up to you to figure that out. But notably, going forward, if these amendments come into pass in their current form, which I'll grant you is a significant if, all motions, all requests for interlocutory relief are to be triaged. All interlocutory motions are to go to a directions conference where judges will be encouraged to give the relief at the directions conference itself, if possible. Or if they need more information, say, please come back to another directions conference, and then I'll give the relief. They can schedule a formal motion, but that is to be avoided. And there are presumptions about what's to be decided where and when. So any instance where there's a dispute over production that doesn't relate to privilege, it will be presumed to be dealt with at a directions conference, and you need a really good reason to have it dealt with at a formal motion. On the other end of the spectrum, if you want a security for cost order, there's a presumption that requires a formal motion. Again, there are areas that there's no presumption either way, such as striking a claim, at least in part. Importantly, at a directions conference, it is to be decided whether or not an action is to proceed by summary process or by traditional trial. And if the judge at the directions conference, and there's a presumption that will be decided at a directions conference, not a formal motion, if he or she decides it is to be dealt with by a summary process, the summary process must result in the resolution of the action. In other words, there will be no discretion at the end of the summary process to say, this actually requires a trial. In other words, there'll be no more failed summary judgment motion. There'll be presumptions in the rules as to what is to be resolved by streamlined process. You can argue you should go on the other path at the directions conference, but once you're on it, it must be resolved. What can be resolved by streamlined process? It would include anything that can currently be resolved by applications, such as enforceability or legality of contractual clauses, certain relief under the Charter of Rights and Freedoms, certain wrongful dismissal matters, other things, quintessentially personal injury matters, have got to go to a judicial trial. You can argue should be on the other track, but that's to be dispensed with exceptionally. And there are also going to be strict timelines. At the directions conference, if you're on the streamlined process, timelines will be imposed that you are expected to comply with, or else. We'll see if this actually comes into pass and whether it's enforced. I will briefly mention what I think are the two most controversial rule changes. These are not controversial, but the two most controversial rule changes that the Rules Committee is proposing is to move documentary discovery essentially to a reliance-based model. Parties must disclose what they intend to rely upon by way of documents, and they also need to disclose adverse documents in their possession. But the point is, they're deciding what's adverse, which a lot of parties aren't happy with. Now, there is discretion for a judge at a directions conference to order more disclosure, but it's presumptively not allowed. Moreover, we're completely getting rid of oral discovery. No questioning in advance of trial. Instead, what's to be disclosed are witness statements that essentially become witnesses' evidence in chief. Interestingly, this is a strange combination of small claims court procedure and international commercial arbitration procedure that will certainly result in things being resolved more quickly if it's implementable. Anyways, I hope you found that interesting. Stay tuned, and I would happily take any questions. Thank you very much.